President of the Law Society, and a senior counsel. Candidates are evaluated on professional ability, standing at the bar, and contribution to the legal profession. Mr. Deputy Speaker, sir, this bill will lead to well-rounded, informed decision about who deserve to be appointed as senior counsel and senior attorneys. A more transparent and fair process improves public perception of the judiciary and the legal profession. In India also, after the case of Jai Singh, as mentioned by the Honorable Attorney General, Honorable Kushal Lobin and Honorable Manoj Siban, after the case of Jai Singh, in India now we have a committee for designation of senior lawyers. The committee comprises of the Chief Justice of India as its chairperson, along with two senior most Supreme Court judges, the Attorney General of the state, and a distinguished jurist who is nominated by the committee. Mr. Deputy Speaker, sir, this bill is a way forward in relation to transparency and fairness. The recommendation panel not only have the Chief Justice as chairperson, but also the Puini judge and the next two senior most Puini judge, but also having the Attorney General, the Chairman of the Bar Council, the President of the Law Society on the recommendation panel paves the way for increased transparency, as the role of the judiciary in granting honorary title to lawyers is separate. If we listen at the Honorable Leader of the Opposition, he was telling why the Attorney General should be on the panel. But if we look at England, India, the Attorney General is present on the panel or the committee. Mr. Deputy Speaker, sir, the composition of the recommendation panel allows for a broader assessment of the candidate's suitability. The key lies in transparency and meritocracy. Mr. Deputy Speaker, sir, the legal profession depends on the public confidence, and a more open and inclusive approach enhances that trust to the wider public. Section 3 deals with the eligibility of appointment of senior counsel and senior attorney who is not less than 15 years of standing. Section 6 explains about the selection exercise, as has already explained by my learned friends. Mr. Deputy Speaker, sir, the recommendation panel also have very specific criteria from A, B, C, D, and E, which have already been elaborated by my friends. Mr. Deputy Speaker, sir, the bill will make the process to appoint senior attorney and senior counsel a transparent one, merit-based process that one unequivocally reflects our society core values of fairness, accountability, and professionalism. Mr. Deputy Speaker, sir, I wholeheartedly thank the Attorney General for bringing this essential bill to the House. He has summarized his position fully and clearly. This bill is a powerful reminder that even the most traditional parts of our legal system can and must evolve to serve the public with greater openness, fairness, and trust. This government's convictions are based on transparency and equality. By continuing to move forward greater transparency, we uphold not only the quality of our legal professionals, but crucially the confidence of the community in the justice system. Mr. Deputy Speaker, sir, I commend the senior counsel and senior attorney bill to the House.
Honorable Penja.
Deputy Speaker, sir. I stand with the House in support, first and foremost, of the Senior Counsel and Senior Attorney Bill, number 23 of 2025. Prior to my address concerning the bill, I wish to perhaps say a few words concerning the Honourable Leader of the Opposition. Sitting alone there, perhaps the solitary chair is taking somewhere having certain psychological effect on the Honourable Member of the Opposition. Perhaps he should, at some point, besides taking nutrients and medically advised substitutes, read the papers circulated for the purpose of gathering in this august assembly completely. Not because he sits in the chair of the leader of the opposition, he's bound to say anything and everything while the camera is pointed towards him. Not because he sits on the chair, he uses that position not to benefit the people of this country, to enlighten the people of this country, but to take the people of this country towards darkness where the MSM is standing today. Why is he not at least sincere to himself? Why is he at each time, every time, being dishonest to what is called intellectual dishonesty? Why does he misinterpret the provisions of the law? When I say provisions, I mean all the time he stood up, he spoke, Deputy Speaker, sir, while misleading the people. Why? If you got nothing better to say, then at least we know, Deputy Speaker, sir, for the last 10 years, he took the vow of silence. Perhaps now, he's venting his vocal cords. Deputy Speaker, sir, this bill addresses issues and ambiguities within the Law Practitioners Act relating to the recommendations and appointment of senior counsel, as emphasized by all the interveners today, and fundamentally and primarily by the Attorney General. This bill brings transparency, consistency, and confidence to a process that carries high symbolic and professional value with and within the legal community of our country. Why do I put emphasis on the with? Because it guarantees that there are representatives from the Law Society and from the Bar Council. And they have got a say in the process. While doing so, I must emphasize, as a Minister of Public Service and Ministerial Reforms, and as a lawyer and former magistrate of the IC, Intermediate Court, my contribution in this debate is not only as a member of the Parliament, but a responsibility which is inherent in all practitioners, law practitioners of our land, but with a personal commitment and principles of justice that is within us, that the principle of good governance that guides us and underpins our democracy. Deputy Speaker, sir, over time, the practical application of Section 9A of the Law Practitioners Act has revealed certain challenges, to say the least, in the way recommendations for senior counsel and senior attorneys are made. While the existing provisions were conceived with the best of the intentions, time has shown that the process demands greater clarity and structure to preserve public confidence and safeguard the dignity of our institutions. The present framework entrusts the Chief Justice with the responsibility of making recommendations to the President of our Republic. Both offices are cornerstones of our institutional democracy. However, even well-intentioned provisions can sometimes give rise to differing interpretations or perceptions that may inadvertently place these highly esteemed institutions under unnecessary public scrutiny. It is therefore both prudent and timely to review the existing mechanism, not as a criticism, Deputy Speaker, sir, but as an act of reinforcement to ensure that the process continues to command public trust and reflect the values of transparency, merit, and fairness. Deputy Speaker, sir, the present bill seeks to reinforce the integrity and credibility of the appointment process by providing a structured framework within which recommendations are made through a process that is objective, consultative, and above all, transparent. The Senior Counsel and Senior Attorney Bill, therefore, provides for the establishment, as we have said, and we say it again and again, a recommendation panel composed of respected and independent figures, which will henceforth be responsible for making recommendations to the President. This shifts the process to a collective and deliberative approach, thus ensuring that decisions are made through consensus and diverse perspectives. The panel reflects the highest echelon of our legal and judicial community, fostering balance and impartiality. We have said this panel, as misinterpreted by the leader opposition once more, consists of 7 members. And the quorum is not 3, it is 5. Deputy Speaker, sir, it should be duly emphasized also that where necessary, provisions are made for substitutions to maintain the panel's integrity, such as designating senior counsel or senior attorneys if the representative, chairpersons, or presidents do not hold those titles, or appointing alternatives by the President of the Republic in case of failure to designate. This collegial structure mirrors successful models in fellow Commonwealth countries, closer to our legal traditions. We have named the UK, we have named British Columbia, Australia, Canada, India. Well, there is also Jamaica, a 7-member committee chaired by the Chief Justice and comprising the President of the Court of Appeal, the Attorney General, the Chairman of the General Legal Council, Presidents of the Jamaican Bar Association Advocates Association, and a representative from the existing King's Counsel group reviews annual applications based on criteria like advocacy excellence, integrity, before recommending to the Governor General on the Prime Minister's advice. A country closer to us, again, South Africa. A Judicial Service Commission including of judges, legal practitioners, and a nominee of the President assesses candidates for senior counsel appointments with a focus on merit and public interest, recommending to the Minister of Justice. On ne réinvente pas la roue. Deputy Speaker, sir, we are but reflecting the evolution and development of the needs of a society which is aiming to refine and ensure that its institutions functions to the optimum. As I said, this collegial structure is further strengthened by clear operational rules. Meetings will be convened by the Chief Justice, first and foremost, or at the request of at least 3 members, with a quorum of 5 members required. Decisions will be taken by a simple majority of those present and voting, thus promoting democratic deliberation. The panel will establish its own practices, and with the Chief Justice as the chairperson, and regulate its proceedings. But crucially, the first meeting must be held within 4 weeks of the Act coming into operation. The bill provides explicit mechanisms to safeguard, I underline the word safeguard, against conflicts of interest. Any member with a personal interest, in a selection exercise must recuse himself and not participate in related proceedings. If conflicts prevent the formation of a quorum, the President of the Republic may appoint substitutes such as the next senior-most Pune judge in place of judicial members, the Solicitor General in place of the Attorney General, or other senior counsels or senior attorneys as needed. These appointments are limited to the specific exercise in question, ensuring temporary and targeted resolutions without compromising the panel's overall independence. Such provisions, Deputy Speaker, sir, align with the recusal protocol seen in Jamaica and South Africa and other parts of Commonwealth countries, reinforcing a shared Commonwealth commitment to impartiality. Moreover, the bill introduces a statutory frequency for recommendations mandating that the panel meet as required, but at least every 3 years to consider and make recommendations, if any. This was notably absent in the previous regime under Section 9A, where the lack of a timeline contributed to perceptions of irregularity and delay. Now the process will be predictable and proactive, honoring deserving legal professionals on a regular basis comparable to other countries around us. In selecting candidates, the panel will consider eligibility criteria. It is well provided in the law. There must be at least 15 years of standing as a barrister or attorney. With names on the roll and not erased while evaluating contributions to the development of the law. Specialized skills, academic distinctions, good standing in the legal fraternity, and other traits of distinction, such as competence, integrity, and fairness. Deputy Speaker, sir, it is worth emphasizing that the title of senior counsel or senior attorney may be an honorary distinction, but I firmly believe it is also a mark of excellence, a recognition of years of dedication, competence, and integrity in the service of justice. It is a distinction that should inspire public confidence and set an example for younger members of the profession to emulate. By introducing a clear and transparent process of nominations, the bill helps restore that sense of prestige and impartiality which such appointments deserve. It ensures that the selection is based solely on merit and professional distinction. Deputy Speaker, sir, I quote, "It is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done." Lord Hewitt, Lord Chief Justice, in the case of Rex and Sussex Justices, 1924, Volume 1, King's Bench 256. This bill, Deputy Speaker, sir, is nothing else but a reflection and a fundamental belief in this dicta. We don't want just to do something. We want our people, the people of our country, to know what we're doing in transparency, in clarity, in objectivity. With these words, Deputy Speaker, sir, I recommend the bill to the House. I thank you.
Honourable members, the Honourable Madam Speaker will take the chair.
Yes.
Merci, Madame le Speaker. Madame le Speaker, je ne le fais pas à chaque fois qu'un projet de loi est devant cette Chambre, mais en cette occasion, je tiens à féliciter le plus chaleureusement possible l'Attorney General pour la présentation de ce texte. Madame le Speaker, avec ce projet de loi, nous passons d'un système arbitraire à un système démocratique et transparent. Et cela sans léser ou humilier qui que ce soit. En soi, c'est un exploit. C'est une chose extrêmement importante et je demande à tous les membres de la Chambre de réfléchir un petit coup, un peu là, à ce qui se passe depuis lundi. Il n'y a eu presque aucune critique depuis lundi. Parce que précisément, je pense, les gens réalisent, d'abord les femmes et hommes de la profession légale, réalisent que vraiment, nous passons d'un système arbitraire à un système démocratique et transparent, et nous avons fait bien attention, ce faisant, de ne léser ni humilier personne. Bravo à l'Attorney General, bravo au gouvernement, bravo à nous tous quand nous allons voter cette loi aujourd'hui. Et comme toujours, en l'absence d'un soi-disant leader de l'opposition qui annonce en longueur les amendements qu'il va move et qui move himself out of the chamber. Nous avons, pourquoi je suis plein de félicitations, c'est parce que nous avons trouvé, l'Attorney General et le gouvernement, nous avons trouvé le bon équilibre qui fait donc, résultat, qui fait la quasi-unanimité aujourd'hui. Le bon équilibre avec 4 juges et 3 membres de la profession légale représentant l'association des avocats et l'association des avocats sur un nouveau recommendation, non, j'espère pas reconciliation panel, j'espère recommendation panel. Ensuite, c'est ce recommendation panel qui recommandera dorénavant au président de la République ceux et celles appelés à devenir senior counsel ou senior attorney. Et ce remuneration panel, décidément, je m'excuse auprès de ce recommendation panel, ce recommendation panel aura, c'est prévu dans la loi, à se réunir and when required, but at least every 3 years. C'est ces petites touches, les unes après les autres, qui fait, de mon point de vue, de ce texte de loi, qui fait de ce texte de loi un petit chef-d'œuvre. Tout ce qui n'était pas prévu, sans humilier personne, sans revenir sur le passé, mais tout ce qui n'était pas prévu, toutes les omissions dans la loi, nous les remplissons tranquillement, mais efficacement dans ce texte de loi. Le président de la République est celui qui finalisera les noms de celles et ceux appelés à être nommés senior counsel ou senior advisor. Tournez pas. Décidément, je suis en forme ce soir. Et pourtant, il est là, il est trop tôt pour qu'il y ait une raison pour que j'ai la langue qui fourche. Mais, oui, c'est le président de la République qui finalisera les noms. Mais le président de la République restera, comme c'est le cas actuellement, comme le prévoit la Constitution, sous l'autorité générale du cabinet. Mon collègue et moi, tout à l'heure, nous vérifions la liste de cas où le président de la République a le pouvoir d'act in his own deliberate judgment. Et je ne réalisais pas qu'il y avait plus de 100 occasions. Parce que nous avons un vrai président de la République. Moi, je suis fier qu'on ait amendé la Constitution en 2003 ou 2002 je crois, pour donner plus de pouvoir et plus de responsabilité au président de la République. Et dans ce cas, le président de la République agit sous l'autorité générale du cabinet. Le Premier ministre rencontre le président chaque semaine. Et si le président lui demande de référer une question au cabinet, cela se fera au terme de cette loi. Le ou la chef juge sera tenu, sous la loi, d'officialiser la liste des senior counsels ou attorneys soumis par le président de la République. Ça n'existe pas dans la loi. Dans un délai de 4 semaines. C'est une demi-douzaine, une douzaine de précisions pareilles qui donnent toute sa valeur à ce texte de loi. Mais encore une fois, sans humilier personne, sans léser personne. Je considère, moi, que vraiment, l'Attorney General et le gouvernement, nous avons réussi ensemble un petit exploit d'arriver là où nous sommes. D'avoir rempli all those gaps, mais sans humilier, sans léser personne. C'est vraiment un petit chef-d'œuvre que nous avons réussi, je le dis sans grosse tête, ou sans vouloir précisément humilier qui que ce soit. Pas du tout. Donc, je suis bien fier qu'on ait réussi ça, qu'on ait réussi ce texte de loi sans humilier personne, sans reprocher quoi que ce soit à personne. On tourne une page et on regarde l'avenir, ou plutôt on laisse ce Recommendation Panel faire son travail d'avenir. De plus, les critères à être utilisés. Avant, il y avait un seul critère, tant d'années comme homme de loi ou homme ou femme de loi, pardon. Maintenant, les critères à être utilisés pour le choix sont dorénavant le choix des seniors, sont dorénavant prescrits dans la loi. Le Recommendation Panel, donc, doit suivre ces guidelines raisonnables et qui aideront le panel à faire son travail. Madame Speaker, avant de préparer ce projet de loi, et pendant que nous le préparions, nous avons examiné, surtout l'Attorney General, mais les autres aussi, chacun a fait son homework, nous avons examiné attentivement ce qui existe ailleurs, mais pas seulement en Grande-Bretagne, pas seulement en Angleterre, en Grande-Bretagne, mais en général. Pour désigner de par le monde les senior counsels ou attorneys ou leur équivalent. Parce que dans pas mal de pays, ce n'est pas l'appellation de ces seniors. Donc, Madame Speaker, résultat de tout cela, mais résultat aussi d'avoir prêté l'Attorney General et chacun d'entre nous au Conseil des ministres, le résultat de tout cela, de tout ce travail fait, mais aussi d'avoir prêté une attention respectueuse, attentive mais respectueuse à tout ce qui a été dit ici à Maurice ces derniers jours à ce sujet. Le résultat, je le répète, nous proposons aujourd'hui, nous tournons la page sur un système archaïque pour introduire un système démocratique et transparent qui fait la quasi-unanimité dans le pays et qui fait honneur au pays. Nous nous en félicitons au gouvernement. Nous avons toutes les raisons au monde de nous féliciter que nous ayons atteint ce résultat. C'est pourquoi je terminerai, Madame le Speaker, en disant bravo et merci, pas seulement à notre Attorney General, bravo et merci à tous ceux qui nous ont aidés à finaliser ce projet de loi. Merci, Madame le Speaker.
Honourable Prime Minister.
Yes, Madam Speaker. Our program 2025-2029 speaks very clearly about our focus for the justice system, improving access for all, tackling financial and serious crime, reforming law enforcement and criminal inquiries, and modernizing our judiciary. Those are the reforms that matter most to our citizens. Those are the changes which we are working hard to bring to this country in this field of our national endeavor. Those, Madam Speaker, are our priorities. Some people, including the Leader of the Opposition, are asking why are we passing this bill? What is so urgent about it? He said that. Well, first of all, the need for a new bill arose because the system broke down. What happened, Madam Speaker, is not well known and understood. Earlier this year, the judiciary transmitted to the President a list of 33 names recommended for appointment as senior counsel and senior attorney. 33. The President, acting under Section 9A of the Law Practitioners Act and Section 64 of the Constitution, decided to appoint 31 of them, that is all except 2. But let me say to the leader, he did not add any name to the list. He had no power to do so. But he didn't approve of all 33, he approved of 31. He could, however, exercise his discretion, and discretion that law grants him. The law grants him that discretion. The Law Practitioners Act says that the President may appoint, not shall. There is a difference between may and shall. It says clearly may. It doesn't say shall. And as you know, Madam Speaker, the Constitution provides in such cases the President acts upon the advice of the Cabinet. In this case, the President deemed it inappropriate to endorse 2 of the names. Why? Because indeed a couple of weeks earlier, the President had issued a proclamation ordering an investigation under the Companies Act into alleged malpractices involving Afrinic. That people seem to have forgotten. Those investigations included looking into whether disciplinary action should be contemplated against those very 2 persons that he did not appoint. In such circumstances, Madam Speaker, any responsible head of state would have done this, should have done the same, and would have done the same. The President had to be coherent. You cannot ask that someone be investigated and then at the same time giving a distinction for integrity before the end of the investigation. The President had to protect the reputation of our country, and on which I must say he did admirably well, and as the Deputy Prime Minister said, he should be congratulated, in fact, that he has acted independently, as he should. Now, the judiciary was informed of this decision by writing to appoint 31 out of the 33 recommended names. But then the President was sent a request to disregard his previous letter of recommendation. But unfortunately, the president, it was too late. The president had already given that the decision had already been taken. That is appointment of 31 and not 33. The latest letters of patent were issued and the appointments published in a communique. It was at that point, Madam Speaker, that rumors started about the list being modified by the president, about the so-called political interference. And this situation led to a case being brought to the court challenging the appointments. And up until now, no ceremony has been called to hand over the letters of patent, leaving the 31 new appointees in limbo. No letters have been sent. These 31 professionals were recommended by the judiciary, not by the president, by the judiciary. And they did not ask for it. They didn't ask for anything. They did nothing wrong. That is what is regrettable. It thus became clear that government should prevent such a situation from happening again. In considering reform, the Attorney General maintained a dialogue with the judiciary, knowing that reason and cooperation would ultimately prevail. The aim was not to impose, but to improve, to make the law clearer, fairer, and more transparent for everyone. Unfortunately, that spirit was soon drowned by a campaign which spread confusion and mistrust. Over the past week, we have read headlines claiming that the president had added names to the list, which is false. He never did. Then we heard that seen the headlines that the bill was designed to bypass the judiciary, which it does not. That it was a threat to judicial independence, which it is not. These claims have been amplified in print and online and by the opposition, by people who should have known better, including the leader of the opposition. The result was confusion that was harmful to the image of our jurisdiction. Madam Speaker, that is why it was urgent that we clarify everything. And we had to act with speed and determination. We have brought this bill before the House today, first, second, and third reading on the same day, because we had to act urgently to prevent this confusion to go on and on and on. When misunderstanding goes unchecked, it corrodes confusion in our institutions. It is our duty to restore clarity swiftly before rumor and speculation hardens into division and before people start believing what they're hearing. I think the leader of the opposition falls in that category. He has believed it, I suppose. Our citizens and our international partners should know that this government will never waver in our democratic ideals, that the separation of powers and the independence of the judiciary is safe, respected, and need to be consolidated. Indeed, Madam Speaker, the bill respects the separation of powers, as I think the Attorney General has explained lengthily. The appointment of senior counsel and senior attorney is not and has never been a judicial function. This is the first mistake that a lot of people are doing. It has never been a judicial function. Nor is it the exclusive prerogative of any Chief Justice. It is not. It is the fruit of a collaboration between the judiciary and the executive conferred by the President acting on the advice of the Cabinet after recommendation by the Chief Justice. That is what the law says today. Some who as often don't do, they are saying that the Attorney General should not be included, as the leader of the opposition said, and in fact he's brought an amendment to that, that the Attorney General should not be included as he is a political nominee sitting in the Cabinet and therefore part of the executive. For the education of those who don't understand, first of all, the Attorney General, a real Attorney General, is meant to give independent advice to the government. Yeah. It is true that unlike the actual Attorney General, the previous one did not give independent advice to the government. They acted as if they were the lawyers of the political party in power. That's how they acted. I can assure the House, not this Attorney General.
In this government.
In this government. Secondly, let me point out, for a long time until some time back, it's Prime Minister Anthony Blair who changed it again for improvement. Before, in the UK, it is the Lord Chancellor who is at the very top of the judicial system. And he is a very senior judge. You don't become a Lord Chancellor in the UK if you're not a very senior judge. The Lord Chancellor actually sits in the cabinet. He or she is a political minister as opposed to the Attorney General who is supposed to give independent advice. And you know what that Lord Chancellor does in the UK? He or she, so far I think it has been he, takes soundings from the judiciary to establish whether someone was sufficiently distinguishable to be given the title of Queen or King's Counsel. That's what he does. Now, after Prime Minister Blair changed it, there is an independent panel which has judicial representatives together with lawyers and non-lawyers. There is a similar system in India as well. So the bill doesn't take power away from the judiciary. It simply clarifies how that power should be exercised through a transparent, structured, and balanced process. In so doing, we have taken on board several suggestions made by the judiciary. We haven't ignored suggestions. As the Deputy Prime Minister rightly pointed out, this new bill increases the number of peonage judges on the recommendation panel from 2 to 4. It gives the Chief Justice the chairpersonship and ensures that the judiciary has a majority on that panel. It also includes the Attorney General, the chair of the Bar Council, and the president of the Law Society, because it is right that all branches of the legal profession be represented. But, Madam Speaker, consultation doesn't mean subordination. The principle of separation of powers means that we consult the judiciary when it is likely to be affected by the law. It doesn't mean that it has a veto over such legislation. There is no principle in constitutional law that provides for such an idea, which becomes even less credible when we try to apply it to a non-judicial function, such as the conferment of a professional rank. The independence of the judiciary implies that it should never hinder its ability to decide cases without fear or favor, whether in terms of procedures, budgets, or otherwise. Not just independent, they have to be impartial, which is very often lacking sometimes, at least. We have therefore taken on board some of the main suggestions of the judiciary. We do not believe, for instance, that we should remove the president from the process. On the contrary, the president, fortunately, acted as he should have. Separation of powers is not a slogan. It is a constitutional discipline. It requires each branch of the government to respect its limit and fulfill its duty. The judiciary must remain free to decide cases without interference. The executive must be free to propose and implement laws, subject, of course, to parliamentary oversight. And Parliament must be free to debate, scrutinize, and enact them. That is how a democracy functions. When one branch of the law, when one branch claims a monopoly over a function that is not inherently its own, as I say, then the balance and the independence of that institution is put at risk. The government has never sought to undermine the judicial independence. On the contrary, we want to enhance its abilities. We have been saying we will invest massively in new judicial infrastructure, in technology for the courts, in reforming legal aid, and modernizing the appellate system. We are the government that will deliver a modern and efficient court of appeal. We have already voted for a revenue tribunal, for legal aid, legal assistance act to be increased, a modern framework for civil and criminal office, and more will follow. This present bill, Madam Speaker, is part of the broader effort. It replaces ambiguity with transparency. It creates an open, accountable system where recommendations are made collectively and decisions are taken lawfully. It prevents paralysis. It preserves the preeminence of the judiciary in the recommendation stage. We all share the same objective, Madam Speaker. A justice system that is fair, that is efficient and trusted. The titles of senior counsel and senior attorney are not privileges to be contested. They are professional ranks bestowed on merit. And in no country, as the leader of the opposition was saying, that there should be an appeal. In no country there is an appeal. Either you get it or you don't get it. You realize I don't think he's looked at it profoundly. If there were to be appeals and contention, well, we'll never finish. We'll never finish. They should not divide the bench and the bar or the judiciary and the executive. They should unite the legal community in service in the Republic. That is why this bill is being brought to the House today. Not to settle scores, but to settle the law. Not to assert dominance, but to restore confidence. We have listened, we have adjusted, and we now ask the House to act to bring clarity where there was confusion and decisiveness where there was drift. The rule of law is not preserved by silence or paralysis. It is preserved by responsibility, by institutions that know their place, the purpose, and the limits. That is what the government stands for, and that is what the bill defends. Thank you.
Thank you. Yes, Honourable Attorney General, your winding up speech.
I hope that my winding up speech, as you very ably characterize it, will not, at the end of the day, wind up anyone. Madam Speaker, I make no apology for taking the time that it takes to respond to the leader of the opposition and his quite extraordinary propositions of amendments and the arguments he put forth against the bill as it stands before the House today. His first critic, his first salvo against this bill was the timing. But let me make it clear, if it has not been made clear enough by my earlier speech, that of the Prime Minister. The necessity for this bill can scarcely be contested. You see, after 22 bills presented to the House since the start of this legislature, this one is the 23rd, 10 months after I stepped in the role. The leader of the opposition must rest assured that this House will be awash with a number of bills of varying importance for the people in the coming weeks. This law is also important for the people, because the people need to know why there is this gridlock I referred to earlier on. It is also important for the 31 legal practitioners who have been appointed whose name have been published and who are still waiting for the official handing over of their latest patent. They are being humiliated by this gridlock, and this has to stop. We must dispel opacity. We must dispel doubts. We need transparency. We need certainty, and this is what this law will give the people. Now let us turn to the proposed amendments. As I said, quite extraordinary. Let me take you to clause 3 of the bill, which the leader of the opposition says we must delete the subclauses 2 and 3. Subclause 2 that he wants to delete talks about non-practicing barristers. Let me tell the House a little story. Most of us have heard, especially those who have studied the law, know of Sir Ian Brownlee QC. Now, he was no practicing barrister. He was an academic. He taught me at Oxford. And you know what? He was the first lawyer approached by the Prime Minister to give advice on the Chagos. And we know what is the result of what he advised more than 20 years ago. So should this eminent jurist not be given that distinction because he does not run around the county courts of UK is abhorrent. And that is why the amendment proposed by the leader of the opposition is not entertainable. The second amendment is subsection 3 of clause 3, where we say that no barrister or attorney shall have a legal right to such a title. As the Prime Minister rightly said, we cannot have a system which will end up in court every other year. We need to make sure that people understand that there is clarity and certainty, and that no one will be able to challenge the ultimate appointment of the President of the Republic after the process through the recommendation panel with the criteria that have been set out in this bill. That is why this second amendment should also be rejected. Now, if we go to clause 4, which is subpart B of the proposed amendments, which we received 5 minutes before Parliament started at 3. So, in clause 4, the leader of the opposition says that we have to delete in clause 3, which is who will sit on the recommendation panel, subparagraphs D, E, and F, i.e. the Attorney General, the Chairperson of the Bar, and the President of the Mauritius Law Society. Now, quite extraordinarily, however, there is no mention by the leader of the opposition of clause 5 of the bill. Can I take you to clause 5, more particularly to subclause 2 of clause 5, where the leader of the opposition has asked for only one amendment. He only wants the name of the Attorney General to be deleted everywhere where it appears only once. Now, more importantly, my alter ego, the Solicitor General, his name is not deleted. What is even more is that although in clause 4.3 we have deleted the chairperson of the bar and the chairperson of the law society, yet in clause 5.2, subsection C and D, the names of the chair of the bar and the chair of the law society are not deleted. What kind of amendment is that? It's a botched amendment. presumably he would ask to amend his amendments. Now, there is more to it. If you look at the amendment proposed at subparagraph B, it starts it's clause 4. Let me take you to subpart 2, where it says by deleting subclauses 4, 5, and 11, and the existing subclauses 6 to 10 to be renumbered as clauses 4 to 8. You are all with me. Now go down that same paragraph in subsection 5. It says, in subclause 9, as renumbered, by deleting the figure 3 and replacing by the figure 2, there is no subclause 9. What are we talking about here? What is this nonsense? And we are being kept away from our homes because of this. Now, one of the issues raised by the leader of the opposition, which had nothing to do with this bill, but he could not mention Afrique. Okay, let's talk about Afrique. What has been said about Afrique is that the President of the Republic had transgressed into the powers of the judiciary when he appointed a judge and relieved him of his duties to do a specific job. They couldn't do it. There was a huge hula in the press, fueled by the opposition. Well, it seems that no one in the opposition realized that there was a decision which said that this was possible. Now, I will tell you who were the judges who sat on that case. It was the full bench of the court in 1995. Chief Justice Forget, he was then senior Queen Judge. Chief Justice Rengapile, he was then Queen Judge. Chief Justice Matadine, who was then Queen Judge. And we also have a Chief Justice, he was then Assistant Solicitor General, Mr. Justice Konai, who appeared for Samorisou, the Attorney General. Let me tell you the story. So in 1995, if some of you remember, Samorisou had retired as a judge, and as all judges, they give an undertaking that they will not practice after their retirement. They can be legal consultants, but they can't practice at the bar. Therefore, they are not on the list of practicing barristers. But when that government at the time needed an Attorney General, Xavier Duval, who was in government,
Yes.
he went to see Samorisou and asked him to come to become the next Attorney General. But he could not because he was not a practicing barrister. He was not on the roll anymore. So, there had to be an application. It is called the application of Samorisou QC. It's a very short, terse judgment, as Chief Justice Pile usually wrote them. I will read some of it because I think it bears reflection and a lot of thinking about what we hear, the nonsense that we hear every day. After taking cognizance of the relevant documents, having heard submission of learned counsel for the Attorney General, we are satisfied that His Excellency the Acting President has relieved Samorisou, former Chief Justice of the Supreme Court, of his undertaking not to practice as a barrister emeritus for the period he will be serving as Attorney General. We take the view, the court said, that if the President can appoint a judge of the Supreme Court, he may, with the concurrence of that judge, relieve him for a particular period of any condition attached to his appointment. And reference is made to Article 1134 of our Civil Code. You wanted Afrique? This is Afrique. And the President was abundantly right. Just like he was abundantly right in taking the decision he took in the present matter. Now, there is more to it. What what the leader of the opposition has tried to portray is that this bill supposedly alters the balance between the judiciary and the executive. With due respect, leader of the opposition, that view does not stand up to scrutiny. The power entrusted to the judiciary has always been a power to recommend to the executive not to decide. That is clear in Section 9A of the Law Practitioners Act, and we are not changing anything. And when you have asked earlier on an amendment, let me go back to your amendment. When you have asked about the amendment to delete subclause 2 and 3 of clause 7, to delete subclause 3 of clause 7 and to amend subclause 2 of clause 7 by deleting the word may and replacing by shall, you probably do not have adequate and proper, correct legal advice. You cannot do that, because if you put shall there, you will need to amend section 64(1) of the Constitution. So it cannot be entertained in any case. And let me finish. So when you also ask for the complete deletion of subsection 3 of clause 7, which places a duty on the Chief Justice to hold the ceremony, what did you say? You said, well, the Chief Justice has to take an order from the President. Come on. That's what we have laws. When the Chief Justice has a law, she has got to abide by it. She abides by it. It's very simple. The law says that she shall do something. It's not the President asking her. It is the law. And have I not heard someone say that no one is above the law, Leader of the Opposition? Of course, Madam Speaker, no one is above the law. And when the law says so, everyone must comply, whomsoever you are. The present bill, Madam Speaker, the present bill keeps the tradition that the function has been shared, because it never belonged exclusively to one branch, the judiciary or the executive. That shared arrangement is now placed in a more transparent, collective and reasoned process of recommendation. True it is that the choice has been to broaden the panel with the presence of the Attorney General and the presidents of the Law Society and the Bar Association. But as the Prime Minister just said, not less than 4 members out of 7, the absolute majority, remains in the hands of the judiciary. And as the Prime Minister rightly stated, that number has not been plucked out of thin air. It is the fruit of consultation with the judiciary. We have listened, we have heard, we have acted, we have amended. Why? Because we wanted a broad consensus. We are not here to impose anything. We are here to make laws that apply, that are certain, and, if at all possible, in consensus. And why would we, if it was our ill intention to remove the power from the judiciary, give the judiciary 4 seats out of 7? Now, the other legal point which the Leader of the Opposition actually dealt with was the separation of powers. And I think it's necessary for me to brush on this because, again, let us not forget the obvious, because shrouded in political mumbo-jumbo. Madam Speaker, the separation of powers is a foundational principle of constitutional government. Even the leader of the opposition would agree with that statement. And it is designed precisely to prevent the concentration of authority in any one branch. Montesquieu thus wrote that liberty depends on keeping lawmaking, law enforcement, and law interpretation in separate hands. If one person had all three, he said there would be an end to freedom. This tripartite balance became the cornerstone of modern democracy. As I said, the balance. In such a system, judicial independence is paramount. We have no qualms with that. Montesquieu and later Tocqueville both stressed that judges must be free from political interference, so that the law alone governs outcomes in the judicial process. We are not in a judicial process here. But preserving that independence does not mean that every judicial custom is beyond reform. The separation of powers protects the functions of judging, interpreting law, resolving disputes, not every practice that has grown around the courts. Our own jurisprudence, and I'll quote this very often, some of you might have heard me say that, our own jurisprudence echoes this principle. In Nordali and Attorney General in 1986, the Supreme Court declared that our Constitution rests on two fundamental tenets, the rule of law and the juxtaposition of powers, as opposed to a separation of powers. And that was not held very lightly. There was a lot of thinking behind that, because precisely there is the interlink between all three branches of the state for it to work properly. It held in Nordali that it is unconstitutional for the executive to overstep or bypass the judiciary in its essential roles, namely protecting the citizen under the law and safeguarding fundamental rights. Now, 2 points need to be made here. First, what is protected is the judicial function itself, the court's ability to adjudicate independently. That is the essential role. Second, the very expression juxtaposition of powers reminds us that whilst powers are distinct, they are often in close contact. They often interact. The Constitution provides many such examples. We can refer to Section 77 of the Constitution, Madam Speaker, when we speak of the appointment of the Chief Justice. Under that section, it might be worth reminding that this is a situation where Section 64(4) of the Constitution would apply. Under that subsection, where the President is directed by the Constitution to exercise any function after consultation with any personal authority other than the Cabinet, the President shall not be obliged to comply with any advice given during that consultation. Even, therefore, the Chief Justice's appointment involves not only a consultation with the Executive, but also a sole discretion given ultimately to the President, which, as you will recall, Madam Speaker, is, as per Section 31 of the Constitution, part of Parliament. All this to say, Madam, that there is therefore nothing improper, nothing sinister in the law that requires cooperation between the branches of the judiciary, the legislature, and the executive. Now, let me end with the wolf. Now, the wolf is me. Je suis le loup dans la bergerie.
Mais est-ce qu'il y a un berger?
Il y a un loup-garou vis-à-vis. Can we get back to some serious matters and finish with this, please? Thank you. So, the onslaught of the leader of the opposition on the role of the Attorney General is totally misplaced and misconceived. Now, if we insist, and I didn't hear the leader of the opposition say the contrary, that we are talking about senior counsel at the inner bar and of the taking of silk, one must also accept another British convention, namely that the Attorney General is the head of the bar. His seat on the recommendation panel is therefore not a political intrusion, but a matter of professional propriety. The Attorney General sits not as a partisan, but as the senior law officer of the Republic, bound by the same duties of integrity and independence as every other lawyer on that panel. Dare I say, I wouldn't think that I would have been chosen in 2010 to take silk if I didn't have these qualities. Similarly, it is being argued that the Attorney General, because he sits on the panel and also in Cabinet, that will later advise the President, there would be a serious case of conflict. This view again, Madam Speaker, as a barrister, you would know this, wouldn't you, ignores the fact that the Attorney General, as a barrister, is perfectly able to know when to abstain from a discussion on account of potential conflict. It is in fact his duty to ask himself that question each and every time the question arises. And by subsuming that I would not, there is therefore the insinuation that I do not know what is my role fundamentally as a barrister and as an Attorney General. I am not the wolf in the bergerie, but I can certainly say, and I will continue to be, the wolf in this House. A wolf guards, a wolf attacks when he is attacked. And in this case, I've had to defend myself. And I apologize if I went a bit too far. But the fact of the matter is, this bill is very close to my heart. And as the Deputy Prime Minister said a number of times, we have heard very hard in the last few weeks to come up with this bill, with the several intricacies that it contains. We have tried to cover all bases. We have tried to avoid gridlock. We have tried to be as open and transparent as possible. We have tried to make sure that everyone understands what we want to do. With these words, Madam, I commend the bill to the House.
Thank you. Somebody's seconding, of course. Prime Minister, seconding. Okay. Thank you. Now, the question is that the Senior Counsel and Senior Attorney Bill number 23 of 2025 be read a second time. Those in favour say aye. Those against say no. The ayes have it.
Committee stage.
Ouais, allez. D'accord.
Yes. Clause 1, short title. Clause
Yes.
2, interpretation.
Go ahead. Yeah. The question is that clauses 1 and 2 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 3, eligibility for appointment as senior counsel or senior attorney.
No.
Speaker,
I
I
call the
move.
leader. Yes. I'm
Thank
sorry.
you, Madam Speaker. I move that clause 3 be amended as per amendment circulated.
The business seconded? No. No secondment needed. I'm learning myself. Okay, the question is, let me see. Don't get me confused. The question is that clause 3 be amended as per amendment circulated. Those in favour say aye. Those against say no. No. The noes have it. Now, be careful. Honourable members, you better be careful because you may say the wrong thing. The question is now, the question is that clause 3 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 4, recommendation panel.
Speaker, I move that clause 4 be amended as per amendment circulated.
You see. Question is that clause 4 be amended. Honourable DPM. May I? The question is that clause 4 be amended as per amendment circulated. Those in favour say aye. Those against say no. The noes have it. The question is now that clause 4 stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 5, conflict of interest.
Yes.
Thank you, Madam Speaker. I move that clause 5 be amended as per amendment circulated.
The question is that clause 5 be amended as per amendment circulated. Those in favour say aye. Those against say no. The noes have it. Now the question is that clause 5 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 6, selection exercise.
Leader.
Yes, Madam Speaker, I move that clause 6 be amended as per amendment circulated.
The question is that clause 6 be amended as per amendment circulated. Those in favour say aye. The noes have it. The question is that clause 6 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 7, appointment of senior counsel and senior attorney.
Leader.
Yes, thank you, Madam Speaker. I move that clause 7 be amended as per amendment circulated.
Question is that clause 7 be amended as per amendment circulated. Those in favour say aye. Those against say no. The noes have it. Question is that clause 7 stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 8, use of honorary titles.
Yes. Clause 8.
Madam Speaker, I move that clause 8 be amended as per amendment circulated.
The question is that clause 8 be amended as per amendment circulated. Those in favour say aye. Those against say no. The noes have it. Don't go too fast. Don't go too fast. Question is that clause 8 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 9, cancellation of honorary title.
Yes, Honourable Leader of the Opposition.
Yes. Thank you, Madam Speaker. I move that clause 9 be amended as per amendment circulated.
The question is that clause 9 be amended as per amendment circulated. Those in favour say aye. Those against say no. The noes have it. The question is that clause 9 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 10, list of senior counsel and senior attorneys. Clause 11, consequential amendment.
The question is that clauses 10 and 11 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
Question is that the title and enacting clause stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Okay, final question. The question is that I do report to the House that the Senior Counsel and Senior Attorney Bill number 23 of 2025 has passed the committee stage without amendments. Those in favour say aye. Aye. Those against say no. The ayes have it. Huh? Okay. Thank you. You may resume your seats. The question is that I do report to the House that the Senior Counsel and Senior Attorney Bill number 23 of 2025 has passed the committee stage without amendments. Those in favour say aye. Aye. Those against say no. The ayes have it.
Third reading.
Madam Speaker, I move that the Senior Counsel and Senior Attorney Bill number 23 of 2025 be read a third time and passed.
Secondment. Yes. The question is that the Senior Counsel and Senior Attorney Bill, number 23 of 2025, be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister, adjournment of the House.
Yes, Madam Speaker, I move for the adjournment of the House to Tuesday, the 28th of October at 11:30 a.m.
Yes. The question is that the House be adjourned to Tuesday, the 28th of October 2025 at 11:30 a.m. Those in favour say aye. Aye. Those against say no. The ayes have it. The House stands adjourned.